Thank you for attending the first panel of our event, Senate Bill 288, Implications for the Criminal Justice System in Ohio, hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A at the end of the webinar. Second, closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Captions in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Doug?
Thank you so much, Holly, and thank you to everybody, both our participants and our attendees, also the entire DEPC staff for helping to put this together. We've had a record number of registrations because everybody wants to figure out SB 288, and we are incredibly lucky to have just an incredible array of folks with expertise and understanding, though I suspect a lot of our conversation is going to sometimes drill into what we're not sure about as this new, very important, very significant criminal justice bill comes online, so to speak. And rather than spend our limited time doing long introductions for everybody, I'm going to introduce folks very, very briefly, kind of as I call on them. I'm, by the way, Doug Berman. I'm the executive director of the Drug Enforcement and Policy Center, and I naturally talk fast, but I especially talk fast when I'm excited to have a lot of such important things to talk about with such a great group. I'm going to start with, and hopefully all of you, know and can see the names of the panelists that are going to be presenting. I'm going to start with Senator Manning because I'm tempted to joke it's his fault we're all here, but it's really his credit to some degree that he helped shepherd this very significant bill. We're going to have a kind of a round robin conversation after he talks about the background of the bill to get different perspectives on which parts of the bill seem most significant or most important from different people's perspective. But before we get into that detail of particulars, in addition to saying welcome, Senator Manning, I want to give you the chance to sort of talk about what was behind this bill, whether you're as proud as I think you should be that this got to the finish line, and whether you're as nervous as I think some of us are about just how it goes from here. And so welcome, thank you for joining us, and please talk a little bit about kind of what SB 288 is, how it came to be, and how you're thinking about it now that we're at the kind of implementation stage after the passage stage came to be at the end of last year.
Yeah. Well, thanks, Doug. Thanks for having me. As you stated, I'm getting a lot of credit and blame for 288, depending on who you talk to. So it's a very interesting bill. It's a very large bill, as all of you know. And really, I mean, I've been working on criminal justice issues since I've been in the legislature. I was the former chair of the Criminal Justice Committee in the House and now chair of the Judiciary Committee in the Senate. So it's an area of passion for me, something that I did in private practice and then also as a municipal court prosecutor. So just something that I'm really interested in. There's a lot of data, there's a lot of information, a lot of different opinions, and it comes across as both conservative and liberal. And sometimes you have interesting people on the same side of different issues. So definitely an interest for mine. And Senate President Matt Huffman has also a lawyer, has a lot of interest in this as well. So when he made me judiciary chair, he came to me with an idea to have a criminal justice omnibus bill. Because there's been a lot of issues that we've worked on over the years, and unfortunately haven't been able to get them across the finish line because, a lot of different groups, you might have 3 or 4 of the big groups out there, prosecutors, judges, defense attorneys, practicing attorneys, and a lot of different groups. If 1 or 2 of them aren't in favor of something moving forward, a lot of times it ends up dying. So his idea was to try to work on some of these big issues that we've been working on for a number of years. Certainly collateral sanction was our intent going into it, and try to get a big criminal justice omnibus bill that maybe everybody, all the interested parties, as we call them, get a little bit of everything. So that's where we started off. We had meeting after meeting with all the people here and many more, basically asking all those experts in the field to come to us with their wish list, what was most important to them. And then we tried to, tailor that to the intent of the bill, the collateral sanctions aspect of it, and that's where we got our start. And then, as many bills do, this one a little more than others. We picked up a few bills along the way as well. So that's kind of the backstory, but happy to answer any questions or continue talking after the others.
I appreciate that, Senator Manning. I should have mentioned that you represent Ohio's 13th Senate District, and so everybody knows kind of where you sit and now where you stand. And I do think, and it's one point that I want to emphasize, especially before we turn into some of the particulars, that it's heartening for those who maybe get discouraged that government doesn't do anything, or there's all this sort of fighting that's taking place, and it's not about actually advancing policy change. And 288, I think we may hear some conversation about concern that it advances too much policy change. It's doing too much all at once, but it's something that I think at the very outset, not only appreciative for your work, but to hear kind of how the process played out. And now I'm going to turn to the prosecutors, the Criminal Sentencing Commission representative, the policy advocates that we have joining us to sort of give their view of their piece of the elephant, so to speak. Right? It's such a big bill. We're not aspiring to. I don't think we could, in the time we have, sort of go over all the particulars of SB 288. And I thought it might be useful then to just start by having everybody sort of talk about their role and their particular perspective on, it can be what they like, what they're not sure about, what they're worried about with respect to the implementation of 288. But, with that sort of just basic theme of what's the part that you're focused on, whether there's one or two provisions that you think are worth singling out in this context for folks to keep an eye on, or that you have a particular interest or concern about. And so we'll start with Lou Tobin. He's the executive director of the Ohio Prosecuting Attorneys Association. Very grateful for you joining us. You obviously can't speak for every prosecutor all the time. My sense is one of the stories is different prosecutors will have different interests depending on what the concerns in their local jurisdiction are. But I'm kind of wondering if you're hearing, or you yourself have identified particular issues of interest, concern, coming out of 288 as we move into the implementation phase now.
Yeah, thanks, Doug, and thanks for inviting us to be a part of this conversation. And I think Senator Manning kind of summed things up well, and I think my members recognize that there are things in this bill that we are particularly happy about. There are things in this bill that we really dislike, and I'm happy to talk about some of each of those. But I think in terms of the thing that's going to have the most positive impact for prosecutors across the state and for victims of crime is the piece of the bill that creates a felony strangulation statute. That was really one of our priority pieces of legislation for the last several General Assemblies. I think going all the way back to 2015, there have been strangulation bills pending in the General Assembly. And they would make it out of one chamber and not out of the other, and then make it out of the other chamber, the next General Assembly, and not come out of the one that it came out of the General Assembly before. And really the dispute had been whether strangulation should be defined within the felonious assault statute and be an F2, whether it should be within the domestic violence context alone and just in the domestic violence statute as a felony offense, or whether it should be a standalone statute and apply to everybody. And that's ultimately where we landed. I think a lot of the credit to that goes to Senator Manning and the Criminal Defense Lawyers Association, I think, who are both really cooperative in our efforts to get that done towards the end of the year last year. And just so viewers, I think, have some sort of understanding of the issue. The issue had been that, first of all, Ohio was one of only two, or maybe the last state without a standalone strangulation offense. So really prosecutors were stuck with a choice between prosecuting strangulation as misdemeanor domestic violence most often, or sometimes they could prove that it rose to the level of a felonious assault and get to a felony of the second degree. And really there was nothing in between those two, when we know that a lot of instances of strangulation are more serious than a misdemeanor, but not necessarily, but proving the serious physical harm isn't something the prosecutor can do. If a victim is made unconscious from a strangulation offense, that rises to the F2 level. But there are I think 50% of even fatal strangulations, there are no external injuries. So it's often difficult to prove what the injuries are. Victims underreport how serious the offense was. And so we needed some middle ground. And that's what the strangulation offense in the bill does. And it makes strangulation a base level F5 offense if strangulation happens between two strangers. It bumps it up to an F4 if the people are in a domestic relationship or a dating relationship. And then it even gets up to an F3 if there's risk of serious physical harm, or if there are prior offenses of violence, or if the victim was pregnant. And then we've still got built in there that it can get to the F2 felonious assault level if the prosecutor can prove serious physical harm. And just the last thing that I'll say about it is, it was important to us to find some sort of middle ground between the misdemeanor and the F2, just because of how dangerous strangulation is. We've had training on strangulation for prosecutors, and we're actually doing a full day of it at our spring conference next week. That says that victims of strangulation are, I think, up to 750% more likely to be a victim of a homicide, a victim of a future homicide offense. So these are just, they're really dangerous people. It's about control. It's about demonstrating control. And so that was important to us for the victims of domestic violence in Ohio, particularly the victims of domestic violence in Ohio.
Thank you very much. And maybe we'll circle back around on things that you're not quite as excited about in 288 and the prosecutors are concerned about, but I want to make sure, and thank you so much for that kind of overview of the strangulation offense. And it's useful if any of my law students are listening. I'm always talking about nuance in the application of criminal law and the challenges that not having the law itself give you the opportunity to have that nuance, and grateful that SB 288 works in this particular setting along those terms. I'm going to turn now to Alex Jones. He's Criminal Justice Counsel of the Ohio Criminal Sentencing Commission, and I'm sure you feel like you're drinking from the fire hose in this context, Alex. But again, the same kind of question I presented to Lou Tobin, which is, are there particular provisions, particular aspects of SB 288 that you have an eye on, that you're following, that you think are going to be either particularly impactful or particularly important to keep an eye on going forward, because there's so much there.
Thank you, Professor, and everyone else has said it, but it's an honor to be here, and I'm happy to talk about this bill. Just like everybody else on the panel, and probably most people listening, I've spent a lot of time over the course of the last couple of months reading, rereading, summarizing, re-summarizing. This is a big bill, and as Senator Manning alluded to, there were a lot of changes, over the course of the life of the bill. In terms of maybe some things that I think are interesting about the bill, or some areas that I'm going to keep an eye on. Obviously it's hard to single out one or two aspects of this particular bill that are of interest, but one of the changes that I'm interested in seeing how it plays out is the change to the intervention in lieu of conviction section. SB 288 included a sunset provision that will now allow offenders for a period of 2 years, as a 2-year sunset provision, will allow offenders who are placed in an intervention in lieu of conviction program to be placed under the general control and supervision of a community-based correctional facility. So CBCS will now be able to supervise ILC program participants. So really over the course of the next 2 years, I'll be interested to see how well this change is received, how often it's utilized, and ultimately whether or not the legislature continues with this expansion beyond the expiration of the sunset period. And additionally, kind of sticking with maybe the sentencing theme, the bill modified the transitional control section in a number of ways, but specifically as it relates to sentencing, one of the changes is that the bill reduces the reach of the judicial veto when an eligible offender is being considered for release on transitional control. So pre-SB 288, the judicial veto is applicable to sentences of 2 years or less. Under the new law, the judicial veto of transitional control is only available when an offender is sentenced to less than 1 year. So, as the plays out over the course of the next couple of years, I'll be curious to see how, if at all, this particular change impacts sentencing.
That's wonderful. Thank you so much. A nice focused answer. Again, like you say, I think it's so hard to pull out a thread from this bill and be, confident that that's the one to focus on when so much else is going on. But, turning now to the advocates, Jocelyn Rosnick, the policy director at the ACLU of Ohio, I'm gonna pick on you with the same hard question. But, my sense is, and I think Lou Tobin was talking about this as well, to some extent, Senator Manning reflected this. These have been a lot of issues you've been working on for quite some time. And then, some of it cashes out in 288, maybe the way you want, maybe the way you don't, others, maybe not so much. And so it's hard to know how to take all this in, but I'm eager to get your perspective on, what particular provisions, what particular aspects of what got done in this bill are of concern to you and your organization and all the work that you all have been doing on the criminal justice reform front.
Thank you so much, Professor Berman. I'm really honored to be here with all of the panelists and you today. So thank you for inviting the ACLU of Ohio. I will just note that the as introduced version of Senate Bill 288, I believe, started with over 1,000 pages. And it did go through many changes over time. It was amended. Some things were added in, a lot of things were pulled out. But as enrolled, it's still about 500 pages. So there's a lot of there. I think that's the best way to describe it. And while there's a lot of there, I will say there's more there to be had. We could talk about that later, but it's really hard to pick a couple of provisions to talk about because there were so many good things in Senate Bill 288. But I wanted to note Ohio's Good Samaritan law and earned credit as two that the ACLU of Ohio are really, really excited about. Generally speaking, Good Samaritan laws grant immunity for minor drug possession offenses, both for the person who is experiencing an overdose and for the individual that is there with them who is seeking some help calling 911. That law is really, really good and necessary in many states. Lots of states have these Good Samaritan laws, and we made some updates and originally passed ours back in 2016, I believe, so a few sessions ago. It's really, really exciting to see the General Assembly take a newer law, see what's working with it, and continue to adjust it based on what isn't working so well. Ohio ranked 4th in the nation in 2020 per the CDC in terms of drug overdose death rates. That's really, really high. It was 47.2 people per 100,000, which was over 5,200 lives lost to overdose. So anything we can do in Ohio to continue to tweak and adjust our laws to combat all of the harms that come with drug overdose is really, really critical. So Senate Bill 288 did two good things related to continued expansion of the Good Samaritan law. The first is that it allows people on probation and parole, so essentially community control sanctions, to be covered by those protections. And, any person that is in a room with someone experiencing overdose should feel comfortable, and we want them to be able to call 911 to call for help. We don't want anyone to not pick up that phone for fear of, criminal prosecution down the line. So Good Samaritan updates in 288 now include folks on probation and parole, and it added protections for possession of drug abuse instruments and drug paraphernalia. So those are two really, really critical updates and some very good expansions on Good Samaritan law through 288. The second thing that the ACLU is really excited about are the significant changes to Ohio's earned credit program. Earned credit is just a fancy phrase for essentially allowing incarcerated people to shave time off of their prison sentence if they participate or complete different types of educational substance abuse and other programming. I think we can all say that there is an undeniable relationship between poverty, incarceration, eventually recidivism. And given that most people in prison nationwide, but also right here in our backyard in Ohio, are going to at some point be released, increased access to earned credit eligible programming is going to end up producing more employable, financially conscious, and also just responsible citizens, which I think we all can agree that we want. I will admit that earned credit is wonky and all of the rules around it are very wonky. And I say that lovingly as a policy wonk myself. So the tweaks and changes to earned credit within 288 are also wonky. But I think there are basically 3 major earned credit updates that folks should be paying attention to. And the first is kind of the biggest, the boldest, the flashiest. Our original ceiling, the amount of time that folks could shave off of their sentence previously was 8%. It's really hard to compare Ohio to other states. It's a little bit apples to oranges based on how all the different laws look. But I can confidently say that 8% was one of the lower rates nationwide. Senate Bill 288 increased that ceiling, that cap, from 8% all the way up to 15%. So it almost doubled it, which is fabulous because the more time, I think the better through this increased participation in programming. It also now mirrors the federal rate through the First Step Act. So 15% puts us more in line with other states nationwide and with the federal limit. So that's a really exciting adjustment. Additionally, 288 did something which I'm really excited about. It expanded the Department of Rehabilitation and Corrections authority to actually create and authorize programs that qualify for earned credit. There are some other provisions about caps, how many days through those types of programs people can actually earn time for. There are some limits based on days or a certain percentage of the time. But what I really want to focus on is the ability now of DRC to actually work on creating programs that they think they can actually implement system-wide at all 28 DRC facilities. And then the third thing to key in on is that earned credit, you can essentially earn different amounts of days per month, and it's based on when you were convicted and the type of offense that you had. Previously, generally speaking, you could get 1 day of credit per month, and 288 increased that to now 5 days of credit per month of participation or completion of different programs. So there are 3 things, right? Going from 8% to 15%, going from 1 day a month to 5 days a month, and then expanding DRC's authority. All really, really good things. I would be remiss if I didn't note that 288 takes care of, I think, half of the problem. We did some additional research into access and consistency in programming across all 28 DRC institutions. And from January to June 2022, essentially what we found is that about 1 in 5 people on any given day, any given month, in any of those 28 DRC institutions, about 1 in 5 were actually earning credit through an earned credit eligible program. I think, 1 in 5 is better than nothing. 20% is nothing to sneeze at, but I would love to see it, upwards of 50% of the folks actually who qualify for earned credit programming to be able to access it. I think
you're bringing up an issue, Jocelyn. I think we'll cover, through our continued conversation, which is it's one thing to change the law, it's another thing to implement it, right? And so that's where you're highlighting, and I think I'm probably reading the room right, that when you call something wonky, we're all flattered, not insulted. And so I think we're good. I didn't mean to cut you off, and if there's anything you wanted to add there, I want to make sure we have time to hear from Kevin Werner, the policy director for the Ohio Justice and Policy Center. I know probably some of the issues Jocelyn mentioned are issues that your organization has worked on as well. But again, I'm wondering if there are other topics, other focal points, both in the advocacy work you did on the way toward 288's passage, but also, now that we're looking forward and thinking about, what provisions are going to really have an impact from your organization's perspective and the way you look at the bill.
Sure. Professor Berman, thank you so much. And it's so good to be with the esteemed panelists this afternoon. And I really do want to to Senator Manning for bringing so much good and needed reform to the revised code. And of course, not everything that winds up in the bill is 100% what is in favor of, but on the whole, we want to talk about the really positive aspects of the bill. And so the record sealing and expungement pieces are really, I think, going to be
informative. And really quickly, here's why. 1 in 3 Ohioans has a conviction of some kind in their past. Okay? 1 in 4 jobs that are available today are off limits for individuals with criminal convictions. The record sealing and expungement provisions are workforce development. Whether or not Senator Manning had that in mind, whether or not Tobin had that in mind, what they've actually done is made it easier for Ohioans who have made mistakes in their past to come back to be productive members of society again by lifting those barriers that are.
Yeah, Kevin, I think your sound is going in and out. I don't know if there's something that's causing that. If you can, I know people want to make sure we hear your emphasis on these topics, and so.
I am so sorry about that. Maybe I'll turn off my screen. Maybe that will help a little bit with the sound. Hopefully it won't continue to do that, but the changes to record sealing and expungement are effectively what the bill has done. It's restructured sealing the statute so that it's easier to navigate and understand. So the way it has done that, it has made many more eligible have their records sealed. The second thing that it's taking 2 different concepts, sealing and expungement. They are very differently. It is making anything that is.
Yeah, unfortunately, Kevin, your sound still going in and out, and particularly for a topic like the distinction between record sealing and expungement, which is such an important topic. You know, I'm needing to hear every word because the terminology is so central to understanding these differences. We'll try to work on your sound. Hopefully we can get you back here. And of course, not to sort of preempt where we're headed, but our second panel is going to be particularly focused on the prosecutor initiated record sealing provisions that are in 288 as well. So we're going to get some coverage of these issues, and sorry, the sound is proving a problem. I'm going to turn back at least for a moment, and then maybe we'll try you again, Kevin, if you've gotten the sound addressed to Senator Manning. You know, anything surprise you in any of the comments from folks about what they thought was really important? I'll warn everybody, and you included. I know Jocelyn kind of flagged the possibility that there was stuff left on the cutting room floor that she would like to make sure whatever the next Senate bill down the pike might include. And so maybe you had a sense of some things that, you know, were in the bill that didn't make it all the way there, or again, hearing from folks kind of about, you know, the provisions that they've emphasized so far. Just love to get your reaction to that in light of, again, the experience you had shepherding the bill from start to finish. And then maybe we'll try to circle back to Kevin to see if his sound is working. And I'm definitely going to want to get back to Lou, because I left him with here's all the good stuff, but I know he's got a little bit of bad stuff.
Yeah, no, I appreciate it. I think all the panelists did a great job kind of highlighting some of the biggest parts of the bill. And a big shout out to Lou, I guess. You know, we worked really close together. We certainly don't agree on everything, but kind of near that end, to be able to get the prosecutors to neutral was a big thing in order to get the bill passed. And strangulation is something that we've been dealing with for many years, and to be able to get the defense attorneys and the prosecutors to agreement was a huge deal, and was able to get it done. You know, in terms of the earned credit aspect that Jocelyn was pointing to, I mean, I think this could be huge for the state, but it could also, quite frankly, not do much, depending on whether or not we properly fund it, whether the DRC makes it a priority. So this could be the biggest aspect of the bill. That's something I'm working on for the budget to hopefully prioritize it. You know, make sure that there's not those waiting lists. Make sure, you know, I think we did incentivize it for more people to want to take these classes, courses, substance abuse, whatever it might be. That weren't offering any of it, others that were extremely long waiting lists. So it's great to put it in the law, but if it's actually not happening, that won't make a big difference. So there's more to do in that aspect. You know, I think policy wise, we covered a lot, and I'm not sure, you know, there's always things that, you know, whether it's bond issues or drug offense, you know, amounts and things of that sort that we'll always continue to work on. And once again, we're going to see how this works. We've already gotten a lot of feedback. We already have a bill in the works that is basically 288 fixes that aren't big deals, but things that LSC has highlighted or the people have highlighted something that may have been missed. We usually see that on more budget bills that are very large. This is a large criminal justice bill. We have a fix. So there are things in the works, but I think for the most part, we want to see how this is working, listen to all the experts out there, and try to be as flexible as possible to be able to fund those projects or make those small changes. So.
Well, we very much appreciate that, Senator, and it's very much part of what the Drug Enforcement and Policy Center, and I think so many organizations are working on throughout the state of Ohio, is to both try to identify what are issues of concern, and again, that's the whole point of this webinar, is to give us a first chance to kind of get an eye and as much of a clear view of some of the things to be watching going forward as this bill gets implemented, and glad to hear there's already follow-up legislation in the works. Kevin thinks he may have his sound working better. So Kevin, without further ado, why don't you go ahead and return to the topics that you were focused on.
Yeah, thank you so much, Professor Berman. Is that better? Can you all hear me a little bit better now?
It does seem like it's better. Thank you.
Okay, great. So the vast improvements that are made to record sealing and expungement, effectively, we're making the statute easier to navigate and understand. There are really only 6 categories of offenses that are not able to be sealed. Those are traffic offenses, those are felony offenses of violence, sex offenses while a person is still on the sex offender registry, offenses where a victim is under the age of 13, first and second degree felonies, and then either a domestic violence or a violation of a protection order. So those are what are not able to be sealed. But everything else is, and that's really where this bill makes such a big change and is going to positively impact Ohioans. Another thing that's really, I think, transformative here is that anything that is able to be sealed can be expunged. They're 2 different tools. Think about it like this for the non-practitioners, and I'm not a lawyer, so I get to put myself in that non-practitioner mode. Sealing is really something that is masking a record. Expungement is destroying. They are 2 very different tools. And so anything that can be sealed can be expunged. Now, there are waiting periods. I think that while we would always argue that the waiting periods should be minimized or shortened as much as possible, the waiting periods do seem to be those which most organizations and interests could agree on. So the big picture is that many more Ohioans are going to be able to have those old criminal records either sealed, and then if and when they get through those waiting periods, then they can be expunged. This improvement is really, I think, designed to get at the collateral sanction problem that so many Ohioans, 1 in 3, are facing. And so it's going to make our workforce more productive. It's going to allow more people to participate fully in the economy. It's going to help lower and keep those recidivism numbers as low as possible. There really isn't, the sky is sort of the limit. There are a couple of things that we would tweak. And that's something that I can have a conversation with Senator Manning around. Just a really quick example would be some definition cleanup. Let me give you an example. Mr. Tobin would probably know that under 2953.39, with the prosecutor initiated sealing, has a real clear definition of what expungement is. The newly created .32 provisions are less clear in the .31. So the policy nerd in me wants to fully talk about this stuff, but I know that we have not a lot of time. But I really can't stress enough how transformative this is going to be for Ohioans. The next question that we're going to be looking at is, does Ohio have the bandwidth, the legal services bandwidth, to now provide those services for all those Ohioans who are now eligible for sealing and expungement? So thanks very much.
Thank you, Kevin. Glad we get the sound right so we can hear all all that you had to say on that perspective, and I'll definitely put a plug in for the work of the Drug Enforcement and Policy Center, both on the kind of the research front and on the service front, because we have as one of our service projects, Opportunity Port, which is trying to make sure people in certain counties even know about record sealing availability, and what you mentioned about definitions and unclarity there can often be a part of it, especially before SB 288 expanded eligibility in the various ways that it did. But also we have a recent study authored by Yana Hrdnova about whether or not we've seen increases in record sealing applications and grants in the wake of prior bills expanding eligibility. And again, it gets to this idea that we were talking about in the prison capacity as well. I know I saw in some of the Q&A mentioning this, you can expand eligibility, you can expand remedies or access, but if you don't have the resources to implement them, it goes underutilized and doesn't always achieve what the legal reforms were there designed to achieve. I'm going to turn back to Lou now in a minute to talk about some of his concerns, but first there's one Q&A I think I can address quickly that I hope Alex has exactly the answer I'm looking for here. One of the folks asked, is there a good overview of all the changes in SB 288 somewhere? And I thought I heard you say you were writing summaries, or maybe those were only for internal purposes, but it's actually a question I've had because I've seen the summary bill analysis that came out, when the legislation was moving through, but I don't think I've seen that many kind of, crisp accountings of what's there. I don't know if that's something you've worked on, Alex, or at least have a sense of whether there's a good answer to that good question.
That is a good question, and you were right. You're right on the money there. I have written a number of different summaries. They are available on the commission's website. They were provided to the full commission at the last full commission meeting, so they're under the materials. And then additionally, we publish periodically what we call the legislative and judicial brief. There's, and LSC obviously has their summary. Mine is the one that I've written is sort of kind of bullet point. I tried to just hit the highlights, and then if people have more information or want more information, they can maybe kind of follow the rabbit hole down the same way that I had to do to get to the summary. But commission's website, so the daily or the legislative and judicial brief includes the most recent one, should include some summary, and additionally the materials from the last full commission meeting included a bullet point summary of all the changes.
That's terrific, Alex. It's a kind of a useful reminder that I even forget sometimes myself, even though I'm on the commission's website all the time, that if you consider yourself part of the wonky community, that's a place to have bookmarked, because you guys do a great job both of developing materials and making them publicly available through your website. And so grateful for that work. And I at least feel like I got at least one of the questions well addressed in this setting. Now I've promised twice, Lou, to get back to you to sort of talk about some of the things that you're maybe not so keen on, or that other prosecutors around the state have expressed to you concerns about in 288. And so, love to hear sort of some thoughts about that, whether they're, again, about implementation challenges, whether they're about, the very nature of the change. Please feel free to share kind of the concerns you see going forward.
Yeah, sure. There's a lot to choose from. But I think first, I should recognize again that in addition to strangulation, there were some other things that I think were of benefit to prosecutors across the state. We got changes to the speedy trial statute that are going to be helpful, changes to the statute of limitations for attempted murder and attempted aggravated murder that are going to be helpful, changes to warrantless searches on community control that are going to be helpful to us. So, there was, again, good and bad in the bill, but I think in terms of stuff that prosecutors are concerned about across the state, it's the stuff that we testified in opposition to earlier on in the process. And it's all of the early release stuff and the record sealing and record expungement stuff. And I think rather than go through just anecdotally why we're concerned with each of those, the perspective on that, in order to understand our perspective on those issues, I think you've got to understand what goes on with recidivism in the state of Ohio and across the country. And so the increase of the earned credit from 8% to 15%, earned credit was originally enacted in House Bill 86 in 2011. ODRC releases a recidivism report every year. And their most recent report, which I think is from 2021, I don't think the 2022 one is out yet, but their most recent recidivism report shows that recidivism rates in Ohio have gone up every single year since 2011. Every year since House Bill 86 was enacted, our recidivism rates have gone up. And that's in the face of artificially tying judges' hands and their ability to send people back to prison. So DRC considers somebody to have recidivated if they're sent to prison within 3 years of release. There are people who are convicted of new felonies in their communities who aren't sent back to prison, who we would certainly consider to have recidivated. So recidivism has gone up since we enacted early release, and we just doubled down on it. Nationwide, the Bureau of Justice Statistics does longitudinal studies on recidivism rates, and they've got a 5-year and a 10-year report out. The 5-year report shows that somewhere around 50%, between 50 and 60% of people who are released from prison recidivate or are arrested and convicted of a new offense within 5 years of their release from prison. Within 10 years, that number jumps to, I think, 75 or 80. So our issue with letting people out of prison early is that we do a terrible job of making sure that they're not going to commit new crimes. And the same thing applies to the record sealing and record expungement issues. You know, prosecutors and judges will have somebody in front of them who they know has been convicted of an offense before. They can see the sealed record on their computer screen, but they can't access it. So from our standpoint, that stuff is just not good for the victims of crime in Ohio. It's not good for public safety. I understand that we want to incentivize people to be rehabilitated. Prosecutors certainly want people to be rehabilitated because they'd be perfectly happy if they didn't have to deal with the same people over and over and over again, but they do. And so our concern is that we've just doubled down on all of that. And the last thing that I want to mention about the record sealing and record expungement is, you know, the anecdote that I just described, where somebody is in front of us that we know has been convicted of something before, I think prosecutors would be less concerned with the idea that we were going to seal records if we could unseal them when that person were back in front of us. You know, if the idea is that, okay, this person has turned their life around, we need to let them seal their record or expunge their record so they can be employable, that's fine, but law enforcement should have access to it if they're back in the judicial system and the criminal justice system at some future point.
So I'm going to try to unpack a little bit of a recidivism conversation and then get to some of the record sealing conversation with some of our other participants. Alex, I'm going to pick on you, and maybe unfairly, I know even more about the work that the U.S. Sentencing Commission has been doing, and they've really leaned into a number of recidivism studies and you know, Lou's expressing kind of that concern, especially as it relates to some of these changes. Is that something that the Ohio Criminal Sentencing Commission kind of has an eye on? Do you think that that's kind of rightly part? I know you guys get way too much work with way too few resources, but you know, is that the kind of topic, you know, how some of the SB 288 changes may impact recidivism, or, you know, recidivism studies always take a very long time to do. That's one of the reasons why they're so challenging, but just kind of from, dare I say, the Sentencing Commission's perspective, you know, concerns about maybe it's a broader story of how 288 will potentially impact, you know, criminal offending more generally, above and beyond the specifics of whether early release or record sealing could you know, contribute to recidivism concerns.
Yeah, I mean, obviously, I think recidivism is a bigger part of kind of the whole story and the work of the commission. You know, I don't want to necessarily set the policy of the commission myself. That's what the 31 members of the commission will do. But certainly, if that's something that they want us to look at, we'll take a look at it as the staff of the commission and make sure that, you know, they're able to fulfill their statutory obligations, on they being the commission members, as it relates to analyzing bills. But you know, I think you kind of touched on this. You know, the breadth of the commission's work relies on information gathering. So, you know, the commission members are going to let us know what information they want so they can analyze the sentencing policy and structure of the state. And certainly I would think that recidivism is something that they're going to want to see at least some numbers on as it relates to some of the changes in SB 288. But we'll certainly be taking a look at anything in SB 288 that the commission wants us to look at, analyze the impacts and, you know, the the better the information that the commission has about the impacts of legislation like SB 288 in terms of recidivism and otherwise, the better the commission can ensure that the people of Ohio are getting the benefit of the criminal justice bargain. You know, as Lou Tobin mentioned, that's public safety, protecting victims, punishing offenders, and you know, giving some offenders meaningful opportunities to rehabilitate.
And Jocelyn and Kevin, I know you've both worked on some of the record sealing and expungement related issues. If you also have thoughts on recidivism, certainly, you know, feel free to chime in on that frontier. Not surprisingly, and I this is among the reasons we've planned the second panel to focus on some of these record relief issues. We've got a lot of questions in the Q&A, you know, lots of specifics that I'm sorry we can't directly get to about whether this offense or that offense is covered, but maybe just particularly a little bit more about kind of a relationship between kind of our historic record sealing approach and now this expanded expungement approach, right? You know, again, both how that relates to just an extra layer of confusion in figuring out what folks are eligible. But one of the questions I thought was really important is, you know, if I've gotten a past record sealed and now it's eligible for expungement, should that be, you know, an absolute, you know, no brainer to go in and try to get it expunged, or, you know, to some degree, obviously there's an individualized element to this, but you know, does that even aggravate some of the concerns that Lou might have that, you know, gee, we've expanded record sealing in the past and now, you know, expungement is just going to add more work and add more layers to the way in which people can kind of, I think destroy was the word you used, Kevin, you know, these records, and at times that could be to ill effect.
Yeah, it's a great question. I think, first of all, I think it's important to understand that when we talk about recidivism, let's be transparent. Not a month ago, the director of the Department of Rehabilitation and Correction testified to the legislature in the budget process that recidivism rates in Ohio are at 15-year lows. When we talk about recidivism numbers, there's two pieces that come together. This is important because I think that you know, a technical violation is a reason for a person to go back to prison who's on some sort of community control, although it may not be a new offense. Yet that person still winds up in the recidivism numbers that I think Mr. Tobin referenced. But to answer the question more directly, you know, should that person go and get their record expunged? Absolutely, because even though a person has their record sealed, there are dozens of agencies and potential employers and third-party background checkers who, while they may not be able to see what the underlying offense is, that's a reason to say, well, maybe I'm not going to call that person back. I don't know what it was 10 years ago, but there's something in BCI's system that maybe I'm not going to call that prospective employee back. And maybe that underlying offense had absolutely no rational relationship between the job a person is applying for and whatever that underlying issue, that underlying offense was. The expungement will destroy it. And so absolutely that person should have their record expunged if they're eligible, and if they've first met that weighting criteria, which by the way is 10 years after sealing. So it's not like we are allowing folks to go into and walk through this expungement, which, by the way, a judge makes the determination as to whether or not that expungement will be granted. But we're also talking about 10 years after all of the other waiting periods that dealt with sealing. So I don't think that, I think there's still more work to do.
And I would just like to briefly double tap basically everything that Kevin said in the interest of time. In terms of the concerns with earned credit, I just want to make a couple of additional points. The data is a little bit stale at this point, but essentially any given year, there's about a 20 to 25% population turnover in DRC prisons, right? So we know the vast majority of people that are going in are coming out, and the waves of folks that are coming out is about a 20 to 25% churn in a given year. Earned credit is not just a rubber stamp. When you complete or participate in a program, there is actually a person, a division within DRC that has to go through and review the time logs to see what type. They have 3 different categories for different earned credit programs that are tracked different ways. And they make sure to see that you actually participated or completed in the program. But then they also do a full review of that person's file. So if the individual violated any DRC or institutional rules or policies or anything else, then that credit can be rescinded for that month. It's not a rubber stamp. It's something that truly does have to be earned, which is why it's called earned credit. And with that, back to you.
Thank you, Jocelyn. Thank you, Kevin. I really appreciate that. I'm going to turn to Senator Manning a little bit, sort of piggybacking off of something that actually Lou Tobin had mentioned when we were talking kind of earlier, and that actually is being reinforced for me as I'm seeing some of the Q&A, although I want to make sure I give a shout out to the DEPC staff for making sure they're trying to get into the chat a bunch of links. Folks should check the chat for links on record sealing and expungement and rights restoration and those changes. The broader documents that Alex described earlier from the Sentencing Commission, summarizing SB 288, that's all available through the links in the chat. And if you have any problems with that, let us know, and we'll try to make sure we get those to you. But Senator Manning, we were talking about the fix bill and what's coming next. These conversations just reinforces for me how challenging it is for lawyers and policy advocates to keep track of everything that's going on. And I think it was Lou who had mentioned in an earlier time that this is such a big bill, and there's been so many changes in the criminal justice space across a range of bills in recent years in Ohio, that there's just a cost and a challenge to everybody working in the system just to keep up, just to understand what's going on. The more complicated things are, the more time has to be spent learning the changes as opposed to doing the work. And I'm I guess particularly interested to get a sense whether you or your colleagues kind of have a feel for how much you've changed the system in recent years, and whether there's at least a sentiment of, maybe this is the time to hit pause for a while, even though lots of people are saying, change this, you left that out, we want you to do this. I'm sure there's always going to be a significant advocacy for changes that people identify and want to see, and problems that arise in implementing old legislation. But is there any sense of we need to sit tight for a while just to see how this plays out? Or is there just kind of that broader pressure that I think legislators always feel, especially in the criminal justice space? Here's a problem, do something about this. Here's a crime that's getting headlines, you got to fix that. Is it impossible to say sit tight in the face of those pressures? Or is it to some degree inevitable that even if everybody's telling you to sit tight, it's a big body with lots of interests that are necessarily going to at least be putting forward bills, if not always, getting those all the way through to the governor's desk?
That's a great question, a hard one to answer. The bill that we're looking at to fix some of the changes, I don't think are big changes. I don't think they're controversial changes. So I think we're kind of wait and see mode on the big aspects of 288. Certainly, in any field, my wife is a teacher. We do things all the time in the education world that changes the rules or the law for how teachers can teach, and sometimes it's very difficult. Some of them are very good changes, but even the good changes, there's a learning curve. There's a problem to that. I certainly have been a practitioner both on the defense side, prosecutor side. I've probably been guilty of complaining about my legislators, as well back in the day because of changes that were made. And with term limits, quite frankly, you have new people coming in all the time. And just because, hey, Lou Tobin and I made that compromise on strangulation 4 years ago, now there's somebody new that doesn't like those changes, and then there could be another change in that regard. And we saw that, quite frankly, with transitional control here. There's a lot of people that said there was already a deal made, and I wasn't there for it, and we came forward and did what we thought was right. So me personally, I'm trying to do the wait and see mode, see how this works, get the data information in from the experts on both sides to see if changes need to be made. Obviously there's things that maybe this bill didn't touch, Judiciary Committee in general or Criminal Justice Committee in general. And I think all the panelists can agree with me here. It's usually one of the busiest committees there are, just because anything that happens in your district where maybe a judge ruled too harshly or maybe too leniently in your opinion, you want to introduce legislation to change that law. So we see so many criminal justice changes from year to year, from GA to GA. And a lot of times, you know, if you've been around for a while, you say, oh, well, that was Representative so-and-so's bill 5 or 10 years ago, but you see similar bills over and over again. So if it gets momentum and a tragedy happens, a lot of times you will see additional changes in the criminal code. But at least from my perspective, as currently chair of the Judiciary Committee, we're trying to, at least on 288 measures, wait and see, push the pause button, see how this goes. And certainly there are things budgetary wise that we need to get, you know, more counselors and more teachers into these prisons, and you know, maybe more funding towards some of the sealing and expungement aspects. That's in addition to the bill. It's not really changes. So that was a very long-winded answer to say, at least I am wait and see and trying to push the pause button for a little while.
As one known for his long-winded answers, I was very appreciative of you speaking on all those topics. And here I already sort of spoke for you, Lou, but I wonder if you could just give voice a little bit more to the kinds of challenges the prosecutors face, you know, in this space with the law changing, and maybe even speak to some of the earlier changes that I know have kept you and your members busy as well, because I think it's something that people can somewhat have a sense of, but I think there's so much more richness and significance to the just the challenges that prosecutors have when the law is moving really quickly.
Yeah, I mean, I think we do face workload issues with this stuff. You know, not only were there additional responsibilities placed on prosecutors because of Senate Bill 288, House Bill 343, which enacted statutory changes to victims' rights, basically implementing the constitutional Marsy's Law provision, placed a lot of new responsibilities on prosecutors. You know, over the last 3 or 4 General Assemblies, we've enacted the Reagan-Tokes Law, which was a systemic change. We've enacted 3 massive changes to our sealing and expungement laws, including what's in Senate Bill 288. We've enacted all these additional changes in Senate Bill 288. And so I am personally, and I think the prosecutors are, an advocate of pumping the brakes and finding out, you know, I think not only does that type of churn create the possibility of drafting errors and legislative errors, it creates the possibility of policy errors. And we need to find out whether what we just did and these last changes are safe for the public and safe for the victims of crime before we go doubling down on them again. You know, I think this might be disputed, but we are living through an uptick in crime. I think I've seen polls that show 68% of people think crime is a serious problem right now. So I think we've got to be responsive to those concerns, and we've got to deal with public safety problems. We've got to deal with gun violence issues that our communities are dealing with, and particularly our metropolitan areas. Uptick in juvenile crime and carjackings by juveniles. So, you know, to the extent that we're talking about what's next, I would advocate for pumping the brakes and I think being responsive to the uptick in current crime.
Hey, you, Lou, I appreciate that. Alex, I'm going to put you on the spot a little bit, partially because of some of the work that I know is going on at the commission in conjunction with the Ohio Felony Sentencing Database, where, you know, there's stuff going on that isn't necessarily coming through the General Assembly directly, and that can have impacts on, you know, the work that lawyers and judges are doing on a day-to-day basis processing criminal cases. I just kind of want to give you an open opportunity, not only to kind of give your perspective on not, you know, more work or less work for the commission, but just, you know, kind of a vision of where SB 288 fits into a little bit of the broader sweep of the range of criminal justice reform efforts that I know are afoot, you know, beyond just legislative changes that you know, I sense you and others at the commission are, you know, directly working on.
Yeah, thanks. And I'll take the opportunity of the open-ended question here to touch on a couple of things. That I should mention that in addition to the resources that I mentioned before, the commission publishes, and I think it might have been sent out, the Felony Sentencing Reference Guide, which is a great tool for prosecutors, defense attorneys, and judges. You know, it's a pretty comprehensive look at specifically felony sentencing throughout the state. And then additionally, in collaboration with the Ohio Judicial Conference, we've been working to update the Adult Rights Restoration and Record Sealing Guide. That should be finished fairly soon. And both of those guides will incorporate all of the changes from SB 288 and other legislation that passed last General Assembly, in addition to some Supreme Court cases. that kind of changed the landscape for criminal justice. So those are good resources. And then, as I'm sure that you know, Professor, and probably many that are listening, over the course of the last year, the commission had put together what is called the Sentencing Roundtable Work Group. And essentially what the Sentencing Roundtable Work Group has been doing is examining the sentencing policy and structure of our state since SB 2 became effective in 1996, SB 2 being the Truth in Sentencing Bill from 1996. So this past December, the work group published a draft report of their findings and recommendations. The title of that was Felony Sentencing in Ohio, Then, Now, and Now What? And that report also is available on the commission's website. So some of the recommendations contained in that work group's report cover topics that really have not been legislatively addressed since Senate Bill 2 in 1996. And, obviously, as everyone is aware, SB 288 was a large bill, but, it really kind of breaks down to a collection of unrelated smaller changes. And really what the statutory obligation of the commission is to study, monitor, report on, and recommend changes to the sentencing policy and structure of the state. So while the commission, has to consider the minutia of the criminal code and each change as they come from the legislature, commission's also tasked with making sure that the minutia fit within a broader sentencing policy and structure. So the work of the commission is never done, and as the legislature continues to tinker with the criminal code, the breadth of the work obviously keeps expanding. But there are obvious, I think, changes in this bill that are going to be important to monitor, and especially monitor in the sense of making sure that they fit within the broader scheme.
Wonderful. Thank you. Thank you for giving a chance to talk about all that you all are doing that's so important for tracking and understanding what goes on with criminal justice in Ohio. So I'm going to turn to Jocelyn and Kevin, to some degree, by virtue of being in groups that does policy advocacy. My guess is, yeah, we need to pump the brakes, but only when we get the stuff done that needs to get done. And so would love to give you a chance. I think, Jocelyn, you mentioned, even a 500-page bill is 50% the size of what it started out. So there were certainly, I assume, things that got left on the cutting room floor that you were interested in. And I particularly would love to hear, especially in light of that conversation we just had, both with, the General Assembly realizing it's done a lot, the prosecutors saying, we're awfully busy, not just from the new changes, but from what's going on in recent years. Kind of what you think still, deserves and needs to be a priority in future reforms, and your sense of just, what still needs to get done, with 288 getting stuff done, but lots more always, kind of on the wish list for a variety of criminal justice reform advocates.
Thanks, Professor. I will start by saying I sincerely hope that our lawmakers don't think Senate Bill 288 took care of criminal justice issues in Ohio for the foreseeable future. And I'm forever, I guess, the optimist, and I really don't think that is the case, or I choose not to believe it. Some of the things that were stripped out of 288 really related to changes that came from the Ohio Recodification Committee report from many years ago at this point. And I think that we still have a lot of work to do in Ohio in the realm of drug-related offenses. Our chief lobbyist, Gary Daniels, has been consistently taking a look at drug possession data in Ohio every year, and has been doing so for quite some time. And what we found last time we dug into it was that drug possession remained the #1 reason that someone actually is sent to a DRC facility in Ohio prison. And that has been the case since at least 2014. And that one offense accounts for about 15.5% of all of the people sent to prison, with no other individual offense even cracking 10%. So I think that's evidence to show that the failed war on drugs is really still raging on in Ohio, and the ACLU of Ohio is really supportive of digging into looking at the issue of drug possession and how that's funneling folks into DRC facilities. I have to say, 288, we have to recognize, was a Herculean effort to get across the finish line, right? It is pretty rare to have an omnibus bill actually make it across the finish line, especially with as many good provisions as it did. There was a lot in the bill. But there is still more that can be done. One of the things that wasn't necessarily tied to 288 that I do want to note, a reform area we hope will continue from last session is pretrial liberty or bail reform. There was no question that that issue was hotly debated in the public arena, but also in the halls of the Ohio General Assembly. Too often, the ACLU believes that either due to a judge or a bond schedule, people accused of a crime who are still legally innocent have to post money in order to be released from jail. If they can't afford to pay that money bond, then they're going to stay in jail. That can be as many as about 60% of all the people in jails across Ohio. And we've done some data in different counties that we can share out later if folks are interested. I just wanted to note bail reform because while House Bill 315 and Senate Bill 182 didn't make it out of lame duck last session, there was a bill, Senate Bill 202, that did get some amendments that created a task force on bail, which to me signals a continued interest in pretrial fairness and bail issues within the Ohio legislature. So I think that there is a lot more work to be done. Senate Bill 202 went into effect, I think, a week and a half ago, and there's a 90-day window to actually create that task force with 3 folks from the Senate, 3 folks from the House. So the clock is ticking. And hopefully, next year, if we're having this conversation, we'll have some really good data to help us in a conversation about what comprehensive pretrial liberty reform could and should look like in Ohio.
Kevin, you want to jump in for
Yeah.
just a minute we still have?
Just really quick. Thank you, Jocelyn. I agree with many of Jocelyn's points. I think that we have to chew gum and walk at the same time. And I say that because here's the good news. While Mr. Tobin is correct that crime rates are slightly high, violent crime rates are slightly higher from 3.1. I'm sorry, from 3.1 to 3.4. So a slight uptick in violent crime. We're still well below the national average, and property crime stayed the same. So yeah, there's a slight uptick, and that's not a good thing. But I think that what we understand is what prevents crime, right? When people have jobs, when people are able to access education opportunities, when people can participate in the workforce, they have opportunity. The more good we do in those areas, that's what's going to keep recidivism rates going the way that we want them. That's what's going to keep property crime and violent crime going down. So I think that we can walk and chew gum at the same time. I think we have to with some of the challenges that face our community. So, from my point of view, yeah, take a breath. But there's still a lot of work to do in the state.
Thank you, and thanks to everybody. My apologies to a lot of the good questions that are there, that so many specifics to cover. I will add in, and maybe this is my putting Senator Manning on the spot as we sort of wrap up. We started with him, and I'm going to end with him. There's, in addition to all the things that we've been talking about, all the good work by so many groups and organizations and players in our system to try to move Ohio criminal justice reform forward, we also still have an initiative process that has in recent years in a variety of ways put criminal justice related matters on the ballot. And I know there's a marijuana reform provision that's something our center follows closely that possibly could be up in 2023. There's every reason to think if that doesn't move forward, there'll be an effort in 2024 to put those topics on the ballot. And so, I'm not sure if it's what else should we be thinking about or preparing ourselves for, or what other factors are in play. But I guess the putting you on the spot, Senator Manning, are there things we haven't talked about, the things that haven't come up in these conversations that either some of your colleagues, you yourself, or others are kind of emphasizing that we could expect to be a point of emphasis, or that other things that people are going to be leaning into. Lou mentioned, others mentioned gun crimes as well. Obviously, that's a national topic, sadly, because of mass shootings and other data on firearm violence. And so, just kind of a last word, both again, as sort of as a thanks but no good deed goes unpunished. Any last word for us here about, what may not already be on our radar screen that you're noticing or you're thinking about as these reform topics continue to generate conversation in the General Assembly?
Yeah, and I was talking about pushing the pause button for, the provisions in 288. I don't think we want to keep moving the target on some of these issues until we see whether or not they're working. But there's always priorities for a lot of, there's 99 state reps, 33 state senators. There's a lot of priorities for all of us. And a lot of them do fall under the criminal justice umbrella, whether that's, we're going to be hearing a bill on, the death penalty, getting rid of the death penalty. We still have a lot of discussion. It was Senate Bill 3 a couple GAs ago on, basically drug possession. I've had talks with the AG and others on that and see if there is a landing spot for that. In terms of bail, that has been a topic certainly nationally, and I think some states, quite frankly, got it wrong. And it's kind of hurt states like Ohio that were trying to maybe do it correctly, because I think some of the topics have changed. Where the Republican Party, which I'm a part of, was a lot of conservatives are looking at trying to be smarter on crime and aligning with groups that maybe would be characterized as more liberal, and that's why I love criminal justice, because everybody kind of works together depending on the issue. And so I don't know if that tune has changed, but most of the bills, quite frankly, that are introduced in our committee are tougher on crime bills. I mean, not criminal justice reform. ACLU does a great report about how many bills are introduced every year. Sometimes, I think I should get, at least from certain advocates, more credit for the bills that we don't pass than the bills that we do pass. But there's always work to be done. I think we'll continue to have those discussions, but with 288 being passed, and so many smaller bills being a part of that, I will say Judiciary Committee, at least since I've been on it, is a little slower so far in this General Assembly than in years past, which isn't a bad thing. I think we got a lot done, but there's still more work to do, and there's still going to be a lot more testimony, a lot more input, and I certainly, myself and the other committee members, we rely on experts like all of you. We're not experts on many of these different subject matters. Now, sometimes the experts disagree, and that's where we come into the play to either introduce legislation or I think there are some things on the horizon, maybe not immediately, but certainly things that we're going to continue to discuss throughout the General Assembly.
Yeah, and I assume it's fair to say, wrapping up, and thank you for those very helpful comments, that the folks listening in on the webinar should contact their senators and representatives and let them know what issues they care about, and continue to understand that thoughtful and respectful lobbying in this space is well received. Let's put it that way, right?
Absolutely, it makes a huge difference, and we have great legislative aides that do a ton of work, and all the information gets back to us. Even if you can't come down to testify to Columbus, please reach out to your reps or senators. Even if it doesn't get a bill introduced or something, it does make a difference. And there's a lot of different resources that we have that we can hopefully help out those interested parties on.
Well, I'm incredibly grateful to you, Senator Manning, incredibly grateful to all of our participants in this first part of our 2-panel series on 288 for making the time and helping us understand what's there. Again, apologies to the folks in the audience not be able to address every question that was raised. That's really one of the themes of what we're doing here, is there's so much to discuss. We can just really scratch the surface, but hopefully it was a lot of meaning folks were able to take out of how well we scratched the surface, thanks to all of you. And I can do the kind of Zoom clap, which is just so meaningful 3 years into the pandemic world. But with that, I'm going to give us a couple minutes to take a little bit of a break. I have the honor of passing the moderator mic, so to speak, to Sarah Andrews, the executive director of the Ohio Criminal Sentencing Commission. She's going to talk us through panel 2 and prosecutor initiated record sealing. And with that, I hope everybody has a good afternoon, and we'll tune in to the second panel so we can learn more about all that's changing and all the good work that appears in SB 288. So thanks again, really grateful to all of you, and please stay in touch. And if there are additional materials that we can make available, through the webinar and to all the registered participants, please feel free to send those our way as well.